of State Prosecutor Billy Downer to be reviewed by the Supreme Court. Now, late last year, you'll recall that Judge Piet Koen dismissed the former president's special plea for Downer to be removed from this case. This is in relation to Zuma's arms deal corruption trial that has dragged on for over 2 decades. Joining us now is legal analyst Benedict Phiri, who talks to us via the virtual platform here in Johannesburg. Mr. Phiri, thank you very much for your time. I want to start off with the comments that were made by the NPA spokesperson a short while ago to our colleague in Pietermaritzburg. And he says that the law makes no provision for an application for leave to appeal by an accused person, meaning, therefore, that only if Zuma is convicted and sentenced does he have a right to bring an application for leave to appeal. Make sense of that for us.
Yeah, I think at first blush, on a reading of the Criminal Procedure Act, that certainly seems to be the case, because when you read the Criminal Procedure Act, it does not provide for appealability insofar as, the Section 106(1)H special plea is concerned, but only confers on an accused the ability to appeal matters such as this at the end of the matter. I think what will be an interesting point for contestation, and the kind of argument you will hear from Jacob Zuma's lawyers, is that, well, we do have a Superior Courts Act, which says that even though we exclude the Criminal Procedure Act from the Superior Court Act insofar as appeals are concerned, that's only to the extent that the Criminal Procedure Act covers it. So I think you'll hear Jacob Zuma's attorney saying, well, it might not be covered under the Criminal Procedure Act, but we do have this Superior Courts Act which would allow us to bring this appeal. So I think that will be a very interesting point for contestation during the morning today.
Is it a foregone conclusion, therefore, Mr. Phiri, that the Pietermaritzburg High Court may not take kindly to the former president bringing this application, which leads to the question, what chances does he have, therefore, of succeeding for leave to appeal there?
I certainly don't think it's a foregone conclusion. I think it will be highly contested in argument today. I'm not quite sure what kind of submissions will be made in respect of each party's position. But when we think about the prospects of success of the leave to appeal, pretty much the former president will be bringing it under 2 sort of general grounds. The first is that in law and in fact, a different court would come to a different conclusion to that reached by Piet Koen last year. And then the second ground would be that even if a different court would not come to a different conclusion, there may be compelling circumstances to bring this appeal. So that, issues such as maybe this is a new area of the law which needs to be developed further. We need to look at Section 106 under the guise of the Bill of Rights. You've heard these arguments from Dalimpofu before. So I think, Mr. former President Zuma will struggle on the aspects relating to the law and the facts, because I think Piet Koen, he stressed in the first judgment that he had his hands tied. Superior courts had pronounced on the matters before, had pronounced on the legal principles, and had also pronounced on the facts that had been determined before. So he couldn't do much about that. But where there might be an angle for former President Zuma to really move this is saying, well, hang on a second, maybe it's time that a Superior Court develops this further, given its nascent development in our law at this point in time.
Speaking about the Superior Court, Mr. Phiri, there is the legal option open to the former president that if it does fail in Pietermaritzburg, he has the option of petitioning the Supreme Court directly to try and argue the matter there, which then feeds into the argument by the NPA that this is yet again the piecemeal approach, which has been dubbed over some time now, that this is the Stalingrad approach that has been employed by the former president.
Yeah, certainly, because, when this matter was certified as trial ready, I think it may have been up to 2 years ago. None of these matters were raised. The former president did not indicate that he was going to bring a special plea when it got a trial-ready certification. So at that point in time, certainly to all the parties, the trial was going to proceed until the last minute. On the day that the trial was meant to proceed, he brought the special plea up. So that is definitely indicative of this piecemeal Stalingrad approach of, taking points by points rather than putting it as a whole. And, the former president will certainly petition the Supreme Court of Appeal if he's not successful today, which will certainly lead to more delays in the matter for sure.
Yeah. An argument has been made by the former president's legal team, Mr. Phiri, that if Billy Downer is ultimately removed from this case, that would pave the way for the former president's immediate acquittal. Is that indeed the case?
Also very nuanced, Xoli, because it depends on the basis on which he's removed. So if we're looking at a Section 106 and he's saying he does not have title, then definitely former President Zuma does have the right to demand that he's acquitted. But what we've learned from the case law and from Judge Koen's judgment is that actually to demand a prosecutor recusal or removal is not linked to 106. It's a separate legal regime. And on that basis, that does not necessarily then lead to an acquittal. Certainly wouldn't, because the grounds for acquittal are then as in 106 and not on this other basis. So it then depends how this would be made. We certainly know that they are facing an uphill battle on the 106 argument, and they haven't developed an argument for recusal separate from 106 that would make it easier to have Billy Downer recused. But we know why. They really want to die on the 106 hill so that there could be an acquittal. But that's certainly quite a difficult case for them to make out.
Yeah. Final question to you, sir. The prosecutor, the senior prosecutor, Billy Downer, is also being investigated. This is after the former president went and laid a charge against him at a police station in Pietermaritzburg. And this is over what former President Zuma is arguing is information about this case that has been allegedly leaked by Billy Downer, stretching back to 2008 and more recently August 2021. Would that have a bearing on this case, or will that have to wait until the prosecuting authority takes it on board and say, well, there does seem to be a case to answer here?
Well, it will certainly hear argument about it today, because this is the new evidence that former President Zuma wants to introduce as part of this hearing of this leave to appeal. Obviously, the question is that will be before Piet Koen is whether, this new evidence, if accepted, will lead to a materially different outcome to what we have at the moment. I certainly don't think so, given, what the title to prosecute 106 plea seeks to really deal with, which is a formalistic title to prosecute. So I don't think it would have a bearing on the 106 application and the former president's potential acquittal. It may have a bearing ultimately on whether Billy Downer, if the NPA gets to that point of taking the matter forward, or the former president does a private prosecution, whether it would be appropriate at that particular time for him to actually step aside from the matter.
Legal analyst Benedict Phiri, thank you very much for always availing yourself to answer these very legally steeped conversations. Thank you very much. Hopefully we'll talk to you sometime soon.